Hi there, and welcome back. We're ready to hit Chapter 3, Legal Environment of Business. So we are going to be dealing with the American legal system. It's a lot of fun, trust me. Some things we'll be looking at in this chapter. Jurisdiction. Who has the right to hear a case? Venue, where the case is physically heard. The structure of the court system. The various actors in the legal system and their relationship to the business community. Very important things for you to know as an aspiring business person. The adversary process. Squaring off with an opposing party. Steps in civil litigation and how you as a business person play a role in civil litigation. And finally, the global dimensions of the American legal system itself. So, what is jurisdiction? So that is the authority or power of a court to hear a case and give a binding decision, meaning that the parties will be required to follow the court's decision. There are two different kinds of jurisdiction. There is original jurisdiction. This is the power to initially hear and decide a case. That is typically known as the trial court, the first court the parties enter into for their dispute. Then there is appellate jurisdiction for the appellate courts. It's the power to review a decision that was previously made by a trial court. In personam jurisdiction, well, that's the right over a person. The plaintiff is the party on whose behalf a complaint is filed. It is the person doing the suing. Defendant, that's the party against whom an action is being brought, the person being sued for some sort of wrongdoing. Complaint and the summons are provided to the defendant via different types of service. A complaint is a detailed statement containing the plaintiff's claim and the relief sought, what it is they want done. That's the complaint. That is detailing what happened and what the plaintiff wants done about it. This is usually accompanied by a summons, which is a court order for the defendant in a civil action to appear before it at a certain time and place, meaning he must answer the complaint. Corporations appoint an agent for service, because as you can imagine, corporations have a lot of legal goings on and a lot of legal papers served upon them. And so they will appoint an officer who is the responsible party for receiving those legal papers. Jurisdiction of courts, state courts, is limited to the borders of the state in which it's located. Meaning, an Arizona state court is not going to be able to hear a court case for a case that was filed in California. Makes sense. Okay. We have this little thing, however, called a long-arm statute, which authorizes a state court to obtain jurisdiction over an out-of-state defendant when that party has sufficient minimum contacts with the state. Long-arm jurisdiction. That's the little wrinkle that we get when, say you're on vacation driving in another state and you cause a serious automobile accident with substantial personal and property damage, and you go home to your home state of Arizona and kind of thumb your nose at people and say, ha ha ha, you can't touch me. That happened in Nevada, and I live in Arizona. Too bad for you. You were traveling through the state of Nevada. You spent money there. It's going to be enough contact for Nevada courts to haul you in front of them saying you have to make right by these residents of ours that you hurt in the car accident. Okay? There is also an rem jurisdiction, which is the power of a court to give a decision that affects property directly rather than the owner of the property, deciding who owns what. We have several court cases involved in Chapter 3. First one is Volkswagen versus Woodson, which puts a limit on state jurisdiction by the Due Process Clause of the 14th Amendment. The 14th Amendment, of course, is the amendment that it requires all states to recognize each other's laws. Okay, so what had happened were there had been a product liability suit filed against Volkswagen in the state of Oklahoma because there was an automobile accident there. The people involved bought the car in New York. It's where the retailer and the wholesaler were headquartered. The court decided that there was not enough minimum contact between Volkswagen and the state of Oklahoma to bring them into this legal action. They did not advertise there. They did not have dealerships in Oklahoma. They did not sell cars in Oklahoma. In other words, Volkswagen did not have enough contact with the state of Oklahoma to be hauled into court for an Oklahoma case. You have to have a minimum contact, a minimum involvement with a state in order to be brought into a case in that state's court. How do you determine what a minimum contact is? Well, there are several factors that have been laid out in the 2010 case of Southern Prestige Industries, which are the quantity of the contacts. Have you never done business there before? Have you only done business there once? Do you only do business there once or twice a year? Do you do business there all the time? Okay? Nature and quality of the contacts. You have a lot of regular contacts in that state. You advertise in that state. Source and connection of the cause of action to the contacts. Again, do you have resources available that you use in that state regularly? Interest of the forum state. Well, there's usually a compelling interest. States have a compelling interest in making sure that their citizens are not harmed. And convenience of the parties. Is it going to be relatively simple for everyone to appear before a particular court or not? Okay. Another type of jurisdiction that we talk about when we're talking about the court system is subject matter. Certain types of courts have authority over certain types of cases. Looking from the top down on this slide, there are cases that can only be heard in federal court. They are admiralty, which is cases involving things that happen at sea, bankruptcy cases, copyright, trademark, and patents, filing a claim against the United States government, claims arising under statutes providing for exclusive federal jurisdiction, prosecution for federal crimes. Concurrent jurisdiction can go either way, state or federal. Is there a federal question involved? Is there diversity of citizenship, meaning are all parties residents of different states? That's the only one that has to be in place in order to appear in federal court. When you have the option available to you of federal versus state court, everyone has to be from different states. State court jurisdiction. This is any or all cases that are not under exclusive federal jurisdiction. We also have the venue. This is the actual geographic location of the court conducting the hearing as prescribed by state statute. This is the courthouse. It's not necessarily the court, it's the courthouse. The state of Arizona, in terms of federal court, is one federal district court for the District of Arizona. There are several different venues for that court, meaning basically courthouses. One in Tucson, one in Phoenix, there's one in Flagstaff, several others that I can't recall right now. That's venue, that's the actual courthouse you're going to go to. That is based on residence of the defendant. They're the ones being hauled into court. Location of the property in dispute. Location where the incident of the dispute occurred. Parties can request that a case be moved. For convenience, too much press, you name it. Structure of the court. Wow. There is, for the federal system, the United States Supreme Court, which is the top court in the land. You don't go any further than that. There are courts of appeals. Those are known as circuit courts. And then there are federal trial courts. Same thing holds true in the state system. State Supreme Court, state appellate court, state trial courts. Okay. So who are our players? Who are the actors in this drama known as court? Well, legal representatives of the parties before the court, attorneys. Qualifications: attorneys have to have a law degree. They also have to pass the state bar examination in the state in which they wish to practice law. That's basically a 2-day test that will grind you right into the ground. I have a law degree. I never sat for a bar exam. Ouch. And you must possess high moral character. What does that mean? Well, it's going to be a case-by-case scenario, I'm sure. When you are working with attorneys, we've all probably seen enough attorney-type television shows to recognize this term, the attorney-client privilege. Information furnished by a client to an attorney in confidence may not be revealed by the attorney without permission. The only exception being is if client reveals to attorney that they are about to commit a crime. Then the lawyer may reveal that information. So if I was in reality a practicing attorney, which I am not, and I am representing a client who has been charged with assault and battery of another person, and my client comes to my office one day and says, I am so mad at that blankety blank, I'm going to kill him. I've got my gun and I'm going to go out and kill him. I can reveal that information. That information does not fall under attorney-client privilege at all. In fact, I am duty-bound to reveal that information. I better call the police, number one. And then, number two, the judge. Work product doctrine. Documents prepared by an attorney in conjunction with preparing for a client's case. These cannot be revealed without client's consent. Attorneys, typically will take extensive notes whenever they meet with or talk to a client, put down their thoughts and ideas based upon client meetings, legal strategies, avenues to pursue. They keep all of that, they write all that information down. Well, wouldn't that be interesting information for the other side to have? It sure would. That's why they don't get it. It's privileged information. Additional functions of attorneys: represent clients in litigation and before administrative board. We'll be talking about agency law later on. May be involved with negotiating disputes with labor unions. Serves as an advisor or a counselor to people, to corporations, to businesses. And of course, attorneys draft a lot of legal documents. We have a trial court judge who presides over the trial. He or she is the person in charge. They make rulings on all motions made in a case. Someone stands up and says, an attorney stands up and says, objection, Your Honor, falls outside the scope of the direct examination. You don't need to know what that means right now. It's up to the judge to say, overruled, meaning sit down, you're wrong, be quiet, or sustained, you're right. So the attorney who is doing the questioning at that time needs to retool their line of questioning quickly. Decides all questions of law. Is this the right law to be applied? Yes or no? Is the law being applied correctly? Yes or no? Rules on whether a piece of evidence is admissible in court or not. Not all evidence presented is going to be admissible. Decides the facts in the case and renders decisions based on the evidence when there is not a jury trial given. And that does happen sometimes. Appellate court judges serve on panels and review lower court cases. There is no new evidence presented here, no new facts presented here. They read the trial transcripts and arguments written by counsel for both parties. They may request oral arguments from both parties, but usually that doesn't happen. They are deciding if an error occurred during the process of the trial and the trial decision making. State court judges are elected or appointed, depends on the state. Federal court judges are appointed by the President with the advice and consent of the United States Senate. So, you're going to be a federal judge in the Federal District Court for the District of Arizona. You will be appointed by the President of the United States upon approval by the United States Senate. Judicial review, that is the power to determine whether a law passed by the legislature violates the Constitution. Justices of the United States Supreme Court are the final arbiters of the constitutionality of statutes. Exercised by individual judges based on their philosophies and attitudes? Yes, that's true. It's called judicial interpretation. That's why whenever an opening comes up on the Supreme Court, everybody gets all agog. Because is the justice that is retiring a liberal, a conservative, or a middle of the road? Everybody gets all agog because if a like-minded judge is not appointed to fill that vacancy, the court can swing in a totally different direction. Ooh, there's rumblings about that right now because there's rumblings that Justice Kennedy of the United States Supreme Court may or may not be retiring. Ooh. And if he does, and who is appointed to take his place, could swing the balance of the court. The court's already swinging towards the conservative end. And if Justice Kennedy does retire now, it's going to go even farther to the right. A judge must exercise judicial restraint. Don't determine something to be constitutional or not, unless it is absolutely necessary to do so. Judicial activism. This is courts taking an active role in encouraging political, economic, and social change. That's one of the big reasons why schools are no longer segregated by race. It's one of the big reasons why same-sex marriage is now legal. Judges undertake social change, and they do this by interpreting law, interpreting the Constitution, and that interpretation can change, as does the morals and beliefs of the society in which we live. Okay. A jury, randomly selected individuals from the area where the court is located. Excuse me. The petit jury, that's just your basic jury. That's the 12 folks. That's the kind of jury that comes to mind when you hear the word jury. They decide on the facts at issue in a criminal case, to pronounce a defendant guilty or not guilty. There's also such a thing as a grand jury. They are convened privately to decide whether enough evidence exists to try a defendant for a felony, and they issue what is known as an indictment. Typically, to be charged federally, you must receive an indictment, a formal written accusation, from a grand jury. That's because you're in federal court, typically your life is much more serious than it may be when you are in state court. Not always. Okay. We operate under an adversarial system, one side against the other. Judges hear evidence and arguments presented by both sides in a case. They make an objective decision based on the facts as applied to the law presented by each side. We do have some criticisms to this system. It has a tendency to ignore contrary evidence, which prevents a fair decision from being rendered. Maybe there is some evidence available that disputes or discredits some existing evidence, but that contrary evidence is not admitted for whatever reason. Extremely time-consuming and costly. Yeah, definitely. There were cases that take a year or more to see the light of day in the courtroom. Certain parties tend to have a distinct advantage. Yes, parties with money. I'm sorry, but that's true. If you've got the money to hire the top legal guns in the area of law you need in your area of the country, you have a heck of a good chance of winning. Okay. Business people, majority of their legal concerns stem from civil law or civil litigation. They have to sue somebody, maybe for breach of contract, or they're getting sued by somebody. Somebody slips and falls on their property and gets hurt and sues them. That's civil law, that's civil litigation. You must follow the rules of civil procedure, which is a set of rules that govern the proceedings in a civil case. It tells you how the case goes. You start and hopefully end, if you're lucky, with informal negotiations. Try and work it out amongst yourselves. Saves time, saves a bucket load of money. If that just simply cannot be done for whatever reason, then a legal action is initiated. Just can't come to an agreement that y'all can live with, and then that's when you go to court. Pleadings are papers filed by a party in court and then served on the opponent. Lays out what the heck you're being sued for and why. Service of process gives the court in personam jurisdiction over the defendant, meaning gives the court jurisdiction over the person. In businesses, corporations, for purposes of law, are persons. Provides the notice of the charges required by the defendant's due process rights. The defendant, or party being sued, is probably going to respond in one of two ways. They're going to move to dismiss the plaintiff's action for whatever grounds, lack of evidence, not true, what have you, or they're going to file a counterclaim. Well, they're saying I did this wrong. Well, they did that wrong. And I want money for that too. That's a counterclaim. Okay. Pretrial motions. This is after the pleadings have been served upon the defendant. The party's request for court action, copy is sent to the opposing attorney. Then we enter the lovely phase of discovery. That is pretrial gathering of information by the parties from one another. What a joyous activity this is. Tools that can be used: interrogatories and requests to produce documents and other items. Interrogatories are a set of written questions that one party sends to the other, and that party must answer those questions in writing and return them. Depositions. Pretrial testimony by witnesses examined under oath. It's kind of like giving testimony in court, but not, because you're not in a courtroom typically. There's not going to be a lot of people around. There's certainly not going to be a jury. There's not going to be a judge, more likely than not. There will be a court reporter, however, to take down all the testimony given and you will, if you are giving a deposition, be placed under oath, same as if you were giving testimony in court. We've gotten through all the discovery somehow. We have all the information there is to have somehow. The judge will then set up a pretrial conference. That is held if a judge finds that questions of fact exist. It happened this way, Judge. No, it happened that way, Judge. It's an informal meeting of the judge with the lawyers representing the parties. Again, we're going to have another go at settlement. Determining the limits of any settlement is necessary prior to pretrial conference. Here's the thing. 90+% of cases that are filed in court, civil and criminal, never make it to court, never make it to the trial stage. They settle out of court. It's the smarter thing to do for a lot of reasons. It's less time, less money. You're a business person. You have your reputation as a business and as a business member of your community. You have your reputation to protect, your business to protect. You don't need a trial being splashed all over the media. Okay? So that's why most cases do settle out of court. But for those who don't, there is a trial. Jury selection, that's a process called voir dire. That is questioning potential jurors to find out if they could actually make a decision fairly and impartially. Sometimes, and we're talking about big money cases here, a side might set up a mock jury, which is a group of individuals in front of whom they practice their arguments before going to an actual jury to find out what the mock jury thinks. Again, this is big dollar cases here. This is like defective automobiles that have killed who knows how many people and caused how many millions of dollars worth of damage. Yeah. When everything is on the line, big money is spent. Shadow jury. It's a group of individuals that sits in the courtroom during a trial, and they deliberate at the end of each day so that the lawyers have continual feedback as to how they are faring with the actual jury that is going to decide this case. Not a good day for you. You need to do something to counteract this, that, and the other. And by the way, juror number 7 is looking really ticked off anytime you stand up. Continuous feedback every day so they can counteract any negative things going on every day. Trials begin after the jury has been selected and seated. They begin with opening statements. Each party's attorney explains to the judge and jury what facts they intend to prove, the legal conclusions that they feel the jury will have to come to based on those facts, so how the case should be decided. Once that's done, the plaintiff presents its case. Direct examination. This is the plaintiff's attorney asking questions of their witnesses they have called to support their case. Redirect. This is questioning by the directing attorney following a cross-examination. Once the plaintiff's attorney has conducted a direct examination, the attorney for the other side is allowed to question that witness as well, and that is known as a cross-examination. Once the cross-examination by the other attorney is complete, the beginning attorney gets to come back for a redirect. Now, the scope of the questioning is always limited to questions that have been asked before. or subjects that have been covered already. Once the direct examination is done, cross-examination, you can only deal with information that was brought out in the direct examination. You can't introduce something new in cross-examination. Motion for a directed verdict can be made by either party. That means, Your Honor, the evidence here proves there's no real question of law or fact, so you need to find for us right now. Those are simple, very rarely are those motions granted. Okay? Then we move to the defendant's case, which is presented upon the denial of their motion for a directed verdict. We move for a directed verdict because the plaintiff has failed to prove his case. Motion denied. Okay, here we go. Go through the same thing. The defense then presents its witnesses. The plaintiff is allowed to cross-examine those witnesses, and then the defense is allowed a redirect. And that just keeps going and going until you're through your list of witnesses. Once all the evidence has been presented, all the witnesses have offered their testimony, the attorneys will meet with the judge and have a conference on jury instructions. These are instructions that are written up by the judges in accordance with instructions from the attorneys as to what the jury may or may not consider and how they are to view certain information that was presented in trial. Closing arguments. Each side gets to sum up their case and then add a brief additional argument called a rebuttal. All kinds of post-trial motions, new trial, appeal of the decision, The end of the trial court case typically is not the end of the case itself. Somebody's probably going to appeal something. Okay. And speaking of appealable issues, we have J.E.B. versus Alabama. This was an all-female jury. And the state appellate court found no violation of equal protection clause of the equal protection clause in the jury selection process. The Equal Protection Clause restricts the ability of the state actors to exercise peremptory challenges on the basis of gender. But you can challenge a person being put on a jury for any reason. And that's just not enough to say, hey, this is an all-female jury because that's what they wanted. No, it's just how the cards fell, Okay, the appellate process depends on the court in which the case was heard. Attorneys can file briefs. Appellate court considers the briefs, they review the record of the case, and they render a decision. There is no new law, no new facts presented on the appeals process. The appeals process strictly is this. Was everything done properly? That's it. Nothing new. Was everything done properly at trial court? Appellate court can affirm the lower court's decision. They can modify it. They can reverse it. Or they can remand it back to the lower court to try again. And once all that's done, parties can then petition the Supreme Court, state or federal, depending on the court you're in. Oh dearie dear. Very, very, very few cases ever hit the Supreme Court. There's just too many. Civil litigation a lot of times involves class action. That involves a large group of individuals who share a common complaint against the defendant. The individuals may not even know each other. Drugs that have been subsequently that a ton of people have been taking that are subsequently proven to have very harmful side effects. Oh, okay. So they all can join in a class action suit and file as one quote-unquote plaintiff. It's more efficient. You have one case instead of 10,000 cases. Okay? The steps involved, the class must be certified by the court. Parties after that can enter into settlement negotiations, and the court has to approve the settlement. Okay? Class Action Fairness Act of 2005 seeks to limit the legal fees of attorneys, allows the defendants to have greater access to federal courts, protects the individual interests of members, and is guaranteed equitable compensation to all members. That's why there's additional court involvement here. They have to certify the class. They have to make sure that the settlement is fair to all members of that class. Okay, global dimensions of our legal system. Well, disputes with other nations are likely to arise and are arising due to multinational corporations and trade relations among nations. Many large corporations have offices around the world, and they're dealing with different legal systems, different procedures, different rights and remedies. And if you're making international agreements, part of that agreement-making process needs to be, if a dispute arises, where do we go to court? Do we go to court at your place or my place? That should be nailed out in the initial agreement to do business. Because trying to fight that one out when a dispute actually rises is going to cost time and money. Don't want to do that. Okay, so we have covered jurisdiction, which is the authority or power of a court to hear a case. The venue, that's where you actually go to court. The structure of the court system, Supreme Court, Court of Appeals, trial court. Same thing for both federal and state levels. The actors in the legal system and their relationship to the business community, well, there's juries, there's lawyers, there's judges, there's witnesses. Your involvement as a business person, aside from the one suing or being sued, is you have to provide your attorney with the information that he needs from you in order to adequately represent you in your case. That's your involvement. You have to work hand in hand with your attorney. I need your business's tax records from the last 10 years. I need your sales invoices from this business for the last 5 years. You're going to be largely responsible for discovery because you're the one with the information. Okay? The steps in the adversary process, we went through all of that. Try and work it out. If you can't, you file suit. Pre-trial stage. The trial stage and the post-trial stage. And global dimensions of the American legal system. Again, most importantly, make sure that if you're dealing with a business in another country, address in your initial agreement where you go to court should a dispute arise. So there we have it. That's chapter 3. Have a good rest of your day, and we will see you again in chapter 4.